Welcome to the Sandwich Crunch, where we navigate the trends and issues impacting seniors and boomers at home, the workplace, and the community. Very excited to be back, and today we are continuing our series on estate planning with my father, Richard Brockett. And what we will be doing is really explaining a lot more detail about estate planning and answering a lot of questions that people generally have and saving a little bit of time going to the attorney right away, but giving you ideas as to why an estate plan is very important for you, whether it's having just a will or having a trust. So welcome.
Thank you.
Well, I thought we'd kick it off because we started off the first series, started off with kind of why we needed to have an estate plan and why having a trust or a will was really important. And then we answered a few questions that the American Bar Association had talked about with healthcare directives. And today I thought we'd start off with answering some very basic questions about estate planning. The basic one to start with, what's an estate?
Well, a lot of people are not quite sure what an estate means. An estate is literally everything that you own or control. That would be your car, your house, your boat, your kids. Don't forget that. They're part of your estate.
Insurance?
Insurance, yeah. An IRA if you have it. A retirement plan. Mm-hmm. Anything whatsoever that you own or control, as I say, is considered part of your estate.
Now, would that also include both titled property and untitled property?
Yes, let's say you're talking about your television set, and it's your set, and that's part of your estate. That is an untitled piece of property that you can dispose of however you want. A titled piece of property is typically your house. Your IRA account has a title and has beneficiaries. So you can kind of look at things that have legal registered documentation. Most of those would be considered as titled property.
And that would include like cars, boats, motorcycles,
Yeah.
A motor home, vacation homes.
All of those have titles.
Okay.
And the non-titled, like I say, is your television, typically your household furniture, any kind of art that you might have, anything that doesn't actually have well, for the lack of a better word, a title that says it's yours.
Right.
So, when you go buy a new lawnmower, there's no title comes with it, but that's part of your estate. So that's considered, even though it's a minor item, it's considered part of your non-titled estate property.
So there's a lot of things that fall into the estate, and you mentioned the kids. So kids are obviously part of the estate, and you have to look at kids both when they're minors and as adults. So when we move from an estate, then what is actually an estate plan?
Well, an estate plan is a plan that you make while you're alive and lucid, and it's a plan that takes into account everything you own, and you decide, what do you want to do with it? Who do you want to give it to? Since unfortunately you can't take it with you, so you have to, somehow or other, you have to decide, who am I going to give this lawnmower to? Who am I going to give my jewelry collection to? All of this is part of an estate plan that you do while you're alive, and particularly while you're in good mental health.
Correct.
That the law recognizes that you can, in fact, make decisions for yourself.
So what happens if someone's incapacitated or is in a place where they are not mentally capable and they don't have an estate plan? Can they create one?
They themselves cannot create it, but I believe that through a power of attorney, they can designate an agent to act just as if it was them, and they can create a viable legal estate plan that way, even though the person is not capable themselves of making the necessary decisions.
Okay. Well, in an estate plan, I know there's one important aspect, whether it's an estate plan with a trust or just your overall estate plan, and that's a will. And I know that there's 3 types of will: the holographic will, which is the handwritten will, the statutory will, and the one that is written with your attorney. So what are your thoughts on each of those?
Well, first of all, a will is probably the number one thing that you do need in an estate plan. Even if you don't have anything else, you need a will. As an example, children, if you want to name who your children are going to go to and be raised by, the will is the only place you can do that. You can't put the children in a trust, you can't put them anywhere else, but you can name
a guardian
who will take care of them in your absence. If you don't, then the courts will do that for you. And it may not be what you want. That's why a will is very important. And it doesn't have to be elaborate. People think that, geez, I'm generating a will, I must be planning to die soon. That is far from the truth. You can generate a will, as I had Bonnie do when she and her husband and kids were going to be taking a trip. I said, and my wife and I were, and his parents were going to be watching these kids. And I said, you guys are not leaving town without a will to designate where these kids go and who takes care of them. So Bonnie was forced into having a will when she was in her early 20s, and that's how important I felt that it was, and still do. Again, it is kind of the foundation. You can have a very elaborate will, or you can have a very simple will that says, everything I have goes to Fred down the street. And that's totally legal, you know, as long as you've done the right things in having your will witnessed, etc. Or you can get very, very elaborate and say, okay, everything I have, I want to have it liquidated, and then I want 10% of the money to go to Fred down the street and 30% to go here, and etc. And you can get rid of everything that way in your will. Like I say, it can be either a simple or a complicated will. And the beauty of it is, if you get it all done today, you get it witnessed, you file it away in your safe or your safety deposit box, and then you wake up tomorrow morning and say, I don't want Fred to have 10% of everything I've got. I don't want him to have anything. Well, you dig the will out and you change it. It's a living document that you can change easily, and there's some minor procedures you have to go through to make sure it's legal. But just because you've generated a will, you don't have to live with that the rest of your life. You can change it anytime you want. Add to it, take away from it, and keep it up to date, basically.
Well, and the 3 types of wills, and I wanted to explain that to the audience, is that there's a holographic will, which is a handwritten will. And you can actually handwrite your will and sign it, as long as there's nothing typewritten in this document. This document is a legal document accepted in the state of California. But as soon as there's something typewritten, and it is, or if it's illegible and it is not completely explanatory in your needs, it will be thrown out of court. There is another will that you can actually go to for the state of California and other states as well, and it's called a statutory will. And you can go right online and write will, state of California, and they will show you exactly where to get it. You can download it right off the internet. You can fill in the blanks, and you have your will done. Or there's another way, which is a will that is completed with your attorney. And those are the 3 types of wills that can be incorporated. So for someone who has a very small estate or something that they don't own a lot of property, maybe a handwritten will is the best avenue to pursue. If you have minors that you need to be concerned about with regards to guardianship or conservatorship, and a conservatorship would be someone that manages the finances of children, those are other issues that need to be placed and you need to be aware of within a will. So within a will, we talked about that it is a legal document, and that as you put it together, there's something called an executor. And what's the executor of the will?
Let me back up just 1 second. Even though wills are very simple to do, a will that is generated and not handwritten, but if it's typed up, done through your attorney or taken off the internet, no matter where you got it, it needs, in the state of California, it needs to be witnessed. Your signature on the will needs to be witnessed by 2 unrelated people.
And non-beneficiaries.
And yeah, they cannot be in any way, shape, or form a part of the will. And that will then make it legal by being witnessed. I have a firsthand experience of a gentleman who thought he was doing the right thing, typed up his will, took it, and had his signature notarized on it. When it got to court, the judge took one look at it, threw it in the garbage can, and applied the laws of the state of California because the will had not been properly taken care of, properly witnessed. So even though it would have been, had he had it witnessed, everything would have been fine. He was, at the time, I presume, unaware that he needed to do that. So saving, I don't know, $100 or whatever it might have cost a lot of money for his heirs.
I agree, and I think that's one thing to be very, very cognizant of when you are putting together your will and working on your estate, is to review it, and it might be worthwhile just sitting down with an attorney and saying, this is what my estate looks like, this is what I have, and they can say, okay, you just need a simple will, or you need to look at some more elaborate measures to set up your estate plan, and we will get into further ones about that. But one thing I do want to clarify is that every state has different rules and regulations regarding an estate plan and wills. So for example, like my dad shared, in the state of California, you have to have 2 signatures by unrelated witnesses and also non-designated beneficiaries for your will. If you have it signed by someone who's within your will, who is a related person to you, it is thrown out in court because a will go into probate, which we will address at a later point. So there's a will, and there's also something called a living will. What's the difference between the two?
Well, a living will is strictly related to medical. And what it is, again, while you're sane, you come up with, and there's all sorts of fill-in-the-blank kinds of forms you can use. You come up with, how do you want to be treated if you are sick or incapacitated in some way, in an accident, or you have a serious disease? How do you want to be treated? And that, again, is something you put together in a living will. There's, all the names escape me at the moment, but there's 3 or 4 other names that a living will goes by.
Well, they would be the healthcare directive. Would that be?
That's one, yeah.
They'd also be I had them all memorized. I'm going an advanced directive. They have different names in different states. That's one of the other issues, is that when you are completing a living will, they do have different names. And you can actually download your advanced care directive from the state of California. You can go online, plug it in, and do exactly what you said. You can fill in the form and say, this is what I want, this is how I want things taken care of. But it is regarding your health. And in that also includes appointing a durable power of attorney, I believe.
Yes, the living will typically is 2 parts. The first part is where you appoint, you give a power of attorney to someone who will act in your place if you're unable to act, unable to make decisions. If you've ever been in a hospital or an ER room, they ask you some of the dumbest questions, like what day is it, who's the president, and they go through all of this. All they're doing is to see whether you are mentally alert and able to make decisions for yourself. If you're not, then this is where your power of attorney, the agent you've appointed, that's where they come into play. That's the first part. The second part then is where you say, this is how I want to be treated. I do want this done, I don't want that done. CPR is a classic example. Do you want to have CPR, or do you want to have all life-saving measures except CPR? CPR is pretty hard on your body.
Especially if you're older and you've got osteoporosis or things like that.
If you're older and you have weaker bones, it can be devastating to have CPR at that point. But this is what you cover in the second half, if you will, of your advanced healthcare directive or living will, whatever you want to call it. They all mean the same thing.
Well, I know there are other things, because I know when we talked about, I know my living will and your living will, we actually used 5 Wishes, which is Aging with Dignity. It's one of the organizations that creates this and accepted by like 42 states. Actually, one of the most portable advanced healthcare directives, and portable meaning that it can go from state to state. Now, not all advanced care directives are portable, and every state has their own rules. So knowing what is portable, meaning you can go and live in Texas and they will honor the same 5 wishes, but they will not in another state. You need to be aware of what your healthcare directive, your living will, how it will be honored as you go from border to border. And also there are other things that need to be taken into account, which are the international issues. And that is a completely different area that we will not address, but that is one you do need to discuss with an attorney, because a lot of these rules and regulations go out the window once you go into another country. And I know that because I know my kids were on a cruise ship one time with their dad, and they were out in the international waters, and a gentleman had had a massive heart attack, and they had an airlift, and he had to go into Canada. So if he had a healthcare directive out of the state of California, it wouldn't apply in Canada unless you have something put in place that can help you do that within the means of that international travel. But I want to address a little bit more on that healthcare directive, because I think people get a little bit confused on what it is that they're actually saying in this healthcare directive, aside from what it is I want. And being more specific would be, do I want intravenous fluids given to me? Do I want antibiotics? Do I want to be taken care of in a certain way? Do I want to be placed in a nursing facility? Do I want to be taken care of at home? If I'm designated terminally ill, do I want to be placed in hospice care, or do I want to remain in the hospital? I mean, it answers a lot of questions, and that is a very, very, very serious document that helps you, and it also gives, I can say from personal experience with Mom, and with, I know we just lost a very dear friend of ours just recently. We were at a celebration of life, and they had done an advanced directive. And knowing what he wanted, it really made it so much easier, gave peace of mind to the children, to the adult children, to the whole family. So knowing these things in advance is very, very important.
Let me interject one thing. With almost all of estate planning, what it is you, while you're alive and sane, are making decisions of what you want to have happen, both to your things and to yourself and to your whatever else you're involved with. And it's a way for you to say, this is what I want to have done when I can no longer make that choice.
Well, that's a very, very, very valid point, and we hope you all take that to heart. For right now, I want to take a quick moment, and I wanted to share with you, I'm now representing Area 12 on Aging. I'm a court-appointed advisory council member, and the council actually represents Calaveras County, Tuolumne County, Mariposa, and it also represents Amador County. And the reason why I'm bringing this up is our county is looking to find seniors that are isolated, and we are asking for your help. We are asking you to reach out if you know of an isolated senior. That means someone who can't drive somewhere, someone who doesn't have a family member close by, someone who is by themselves, remote from other places, whether it's geographic or they're remote simply because they have no communication means, they don't have a telephone. Any way that someone may be isolated, they may not be able to get to church, or they may not be able to get to the grocery store, we are seeking your help to help us connect with them because we can provide them very, very valuable services. So I ask that if you do know of someone to please contact Area 12 on Aging. You can reach them at area12.org, and you can also contact them at 532-6272. So now we're going to head back into our discussion about wills, but now we're going to talk about what happens if you don't have a will. So Dad, what happens if you don't have a will?
Well, if you haven't written a will and you pass on, then it will go into court, which all wills go in for probate. And the state of California, through the courts, will say, oh, you don't have a will. Well, guess what? We have one for you. So the state of California has a whole book of laws that address what is going to happen to your estate since you didn't bother to tell anybody what you wanted to have happen. So your favorite fishing pole is not going to go to Fred down the street. It might go to totally somebody else. Definitely not what you wanted to have happen. So if you do not have a will, you're considered to have died intestate without a will, and one will be provided for you through the legal system. So essentially, if you want things to go where you want them to go, then you need to generate a will.
Yeah, so if you want to control your estate and how it's divvied out and who gets what, if you want your great-grandson to have that fishing pole, you need to have that written in there. Or if you want to have all of your estate to be donated to the Humane Society, you can do that too. But if you don't have that written down, the court will designate that for you. And also to clarify that, again, every state has their own rules. Yeah. And I think when people hear probate, they don't quite understand. This is a trial. You are actually going in front of a judge. You are in a court. It costs money. It costs money to hire attorneys. You have to pay for accountants. I mean, so the family's left with this in their hands, where they have a lot of expenses that come into their play. And then it also extends the ability to hand off or pass on the items in your estate, whether it's the financial aspects of it or property or so on, because it's now all stuck in the legal system. And I actually just did some research, and the average time in the state of California for probate is 8 to 12 months. That is given that there's nothing unusual. No one contests the will, so maybe that far-off cousin who's that fifth related cousin shows up and contests the will, says, I need this. Then we have a lot of other issues that show up. So that is a very, very valid area and very complicated area, but one you want to avoid if you can. And having a written will not avoid probate, but in another part of our series, which we'll be getting into, will be a trust, which will help you avoid probate.
Yeah. One statement about wills. All wills will go through probate. Now, that doesn't mean it's going to take 12 months to get through it. It might be done the same day they look at it. They might look at the will and say, okay, everything is in place. We can turn this over to the named executor, and essentially it's a done deal. It can be relatively quick, or it can drag on and on and on.
And that's the last thing you want to do. So as a gift to your family, right now we've already talked about what an estate is, what an estate plan is, and what a will is, and the different types of wills. The first place to start is writing your will and making sure you have that set up for your family, because that's the best gift you can give, not only to yourself, because you have control. You're in control of it now. As you are alive, you can change it like my dad said. But if you don't do it, you have no control. You lose control over how your assets are divvied out. So in our next series, we will be going into a little bit more depth about other aspects of the estate plan. And we hope that you will join us. And Dad, any other comments you want to make on wills at this point right now?
Well, as I believe I said, a will is a very simple document to put together, and it's the basis for an estate plan. Once you have a will in place, all of the other things that we will discuss here and that you'll find listed under an estate plan, you can either go ahead with those different things or not, and it's going to have it depends on you and your estate. It's not mandatory. The will, in my estimation, is the only mandatory thing, excuse me, that you do need to address. And one thing about a will, there's something called an estate tax, and there's both federal and state estate taxes. A will have no effect whatsoever on estate taxes. You have to do other things if you want to, if you're involved, if your estate is large enough to trigger the taxes, there are other things you have to do. A will doesn't accomplish any of those.
No, but it's a good starting point for anyone out there, and it can be started at any age. And I recommend anyone 18 years and older to have a will, and you review it on a regular basis, review it annually, and you review it especially at different stages of your life. Especially if you're single, then you get married, because then now you have a couple. When you have children, it changes. When you get older and you retire, then there are a lot of other issues that come into play. And then as you age, as we are aging longer, there are a lot of other issues that come into play. So there's a constant review of a will that needs to be taken place. But at this point, what we're going to do is close and say thank you for joining us, and we look forward to having you on our next set of estate planning series, and a really good look at, a little bit further look at the probate, and looking at trusts and other aspects on how you can set up something that will give your family peace of mind, give you peace of mind, and give you absolute control over your life now and thereafter. Once again, thank you for joining us on the Sandwich Crunch, where we navigate the trends and issues for seniors and boomers at home, the workplace, and the community.